Good afternoon. Welcome to the Appellate Division First Department Oral Arguments for December 2, 2020. I will now call the calendar. People versus Thomas Berdetti, submitted. Cruz Guzman versus 2380-2386 Grand Avenue, submitted. G. Ivani versus Martin B., submitted. Reichenbach versus Jason Investors Corporation, submitted. Cropper versus M.D. Stewart.
Brian Shute appearing for the appellant, Your Honor.
You have 4 minutes.
Thank you.
People versus Wilmary Derry Chirino.
David Clem for appellant. Good afternoon.
Good afternoon. You have 3 minutes. Salcedo versus Sun Nation Thermal.
Good afternoon, Your Honor. Chris Savro on behalf of the appellant, Mr. Salcedo.
5 and 2.
Good afternoon, Your Honor. Sean Burns, Kennedy's on behalf of Respondent Strathmore.
You have 5 minutes.
Good afternoon, Your Honor. Kurt Gilfillan on behalf of defendant respondents, Gemstone, DHNY, and Sustainable.
You have 5 minutes as well.
Thank you, Your Honor.
Tawari versus City of New York.
Good afternoon, Your Honor. Julia Quigley for appellant.
5 minutes.
Your Honor, may I reserve 1 minute for rebuttal?
Definitely.
Thank you.
Good afternoon, Your Honor. This is Amy McCanfill for respondents.
5 minutes.
Thank you.
Barber versus A.O. Smith. Appellant. A.O. Smith. We'll come back to them. People versus Jose Rodriguez, submitted. Alima versus Osamane, submitted. Star Indemnity versus Monte Carlo.
Good morning, Your Honor. Franklin McRoberts, Farrell Fritz, PC for defendants, appellants, respondents, Monte Carlo, LLC, and Dorchester, LLC.
So, appellant, you have 10 minutes. Did you wish any time in rebuttal?
May I reserve 2 for rebuttal, Your Honor?
Certainly. 8 and 2.
Thank you.
Respondent.
Lauren Bristol for respondent cross appellant. 10 minutes, please.
Yes. Itria Ventures versus Provident Bank.
Ron Rossi from Kasowitz Benson for appellants. I'd like to reserve 2 minutes for rebuttal, please.
8 and 2. Provident Bank.
Good afternoon, Your Honor. John Stoker from McCarter and English. I'd also like to respectfully request that my colleague, Joseph Lubertazzi, who's a member of the bar of the state of New Jersey, be permitted to argue this appeal on behalf of the respondent.
And you have 10 minutes.
Thank you, Your Honor.
People versus.
Thank you, Your Honor.
You're quite welcome. People versus Christopher Stewart, submitted. Freed versus Palaco, submitted. Price v. Turner Construction, submitted. Demerjian versus Demerjian, submitted. Shapiro versus the City of New York. Appellant.
Good afternoon, Your Honor. Judy Shaughnessy for petitioner, Your Honor.
5 and 2. City.
Thank you, Your Honor.
Good afternoon, Your Honor. Alan Rosinas for the respondents.
5 minutes.
Thank you, Your
People
Honor.
versus Carlos DG.
Good afternoon, Your Honor. Paul Wiener for the appellant.
4 and 1.
Good afternoon. Rachel Bond for the people.
4 minutes.
Thank you.
Ellis versus JP Morgan Chase, submitted. US Bank versus Beamer, submitted. Neo Universe versus Kanabu, Ito, submitted. Markelson versus Samadi.
Nicholas Tam for the appellant, Lennox Hill. Good afternoon, Your Honor.
Good afternoon. So you have 5 and 1.
Thank you.
Good afternoon, Your Honor. Joseph Lanny for the respondent.
And?
Good afternoon, Your Honor. Jacqueline Pisano for appellant Dr. Samadi.
Okay, so that's 5 and 1, 5 and 1, and 5.
Yes.
So it is the rule of the court that you not speak over the justices. And so when we're doing this remotely, it's even more important that you not do so. Also, as was stated by Ms. Rojas, we ask that you please keep your mics muted at all times. Otherwise, it creates a feedback, okay? So
Your Honor, Your Honor, I hate to violate the rule, but could we go back to the Barber case? I didn't have my microphone on and I apologize.
Yeah, so you violated the rule immediately. Okay.
Defendant Appellate
okay.
Kohler, 8 and 2.
Yeah. Is the respondent on here?
Yes, Your Honor. Jason Weinstein for respondent plaintiff Karen Barber.
So were you guys together when the case was called initially? Okay. So we'll try this again. Keep your mics muted. Don't talk over the justices. First case on for argument, Cropper versus MD Stewart. Hello, appellant?
Whoops.
Is anybody here?
I'm trying to unmute.
Oh, you're successful.
Oh, good. Okay, now I can't see you, however. Oh, well.
As long as we can hear you. That's
okay, that's good. I'd like to start by acknowledging the elephant in the virtual room, Your Honor. The plaintiff lost this case on the merits in this court. There's more than $9 million of damages, and if plaintiff prevails on this appeal, the Transit Authority would be liable, notwithstanding the fact that it prevailed on the merits. Having said all that, number one, that's the result that the statutes here direct. And number
Mr. Shute, before we even get to the issue of the statutes, how in the world do we have jurisdiction? As you acknowledged, the case was dismissed on appeal in 2014. 6 years later, we have jurisdiction over the Transit Authority?
Your Honor, there's always continuing jurisdiction. For example, under CPLR 5015, where a party, plaintiff, defendant, it doesn't matter, obtains summary judgment, the other party can afterwards not start a new action, but make a motion on the 5015 to overturn the judgment on, amongst other grounds, newly developed evidence. And the party that prevails on the appeal may even continue on afterwards, for example, to obtain costs. If that answers your question, I'd like to go to the statute.
Well, but it doesn't answer my question because there's nothing pending before us to decide. I think that's the problem I'm having.
Well, in all of these cases where you have a judgment entered, there's nothing pending until the application is made in the lower court. For example, a motion to set aside the judgment under 5015. It's that application which we made by motion in the lower court and the ruling with respect to that gives this court appellate jurisdiction with respect to that ruling.
Okay, assuming that's correct, what about the fact that Stewart never asserted any cross claims against Transit?
Well, of course, he defaulted, so he wasn't going to assert any cross claims. But
whether he defaulted or not, there still were no cross claims asserted against Transit. And going back to my colleague's point, the matter was still dismissed as to Transit. So again, I'm not certain as to how we would have jurisdiction.
Again, Your Honor, it's the same way jurisdiction exists in the other situations. And I would add that this is indemnification. The statute doesn't even begin to run until the party seeking indemnification has been held liable. And the lower court addressed this in the interests of judicial economy. And if the court finds there's any problem with respect to the jurisdiction here, it might consider that as well.
Mr. Shute, I understand that you argue that there was a conflict, there would be a conflict if Mr. Stewart asserted a cross claim, but certainly once he no longer had counsel and he was pro se, there was nothing to prohibit him from asserting any cross claims, right?
That's correct, but the fact that he didn't assert a cross-claim doesn't bar him from seeking indemnification from the transit authority. But of course, you're correct with respect to that premise.
Yeah, I just have another question. Certainly, how do you respond to the transit's argument that Article 7 of the bylaws, supplanted 12.12.3? How do you address that? Because it adopted POL Section 18 and it supplanted 12.12 Subdivision 3. So how do you address that?
I am so glad you asked me that. You have two statutes here. Section 12.12 of the Public Authorities Law, it's specific to one entity in the world, this one, the Transit Authority, and Section 18 of the Public Offices Law. And the argument made below and credited by the lower court is that the Transit Authority adopted the Section 18 Public Authorities Law under Subdivision 12. And if you look at the last sentence of that, it allows a public authority to do that. My point is that, number one, obviously the more specific statute would control, more specific to this authority, and also the other result would render that entire subdivision a nullity. But with respect to the question of adopting it, and the Sky Mecca case in particular, on which the lower court relied, when you look at Sky Mecca, what you'll find there, that concerned Education Law 3811. And what happened there was a human rights case brought against the school, which was respondent, and petitioners who were employees of the school. They wanted separate counsel. It was the school, Your Honor, that relied upon Section 3811 of the Education Law. And because they relied on it, and their argument was a conflict of interest may get you separate counsel under the POL, but it doesn't get you separate counsel under the statute. And what the Appellate Division ruled there, Your Honor, it ruled in favor of the petitioners on that issue on the grounds that the more favorable to the employee statute controlled. In that instance, the more favorable to the employee provision was that of POL 18, since that one did allow for new counsel in the event of a conflict of interest. I should add that was dictum, because then the court went on to find there wasn't a conflict of interest anyway. But the part of the statute that the Transit Authority and lower court relied upon says, in essence, exactly the opposite of what the Transit Authority is here doing, using POL 18 to limit the rights that would otherwise exist under its statute, Section 1212. And when you look at last sentence, Your Honor, of Subdivision 12 of POL 18, it says, unless the governing body of the public entity shall have provided that these benefits, that is from POL 18, shall supplement and be available in addition to defense or indemnification protection conferred by another enlargement. Exactly the opposite of what the Transit Authority is attempting to do here.
Thank you, Counselor. Does anyone else have any additional questions? Thank you so much, Counselor. We appreciate it. The next versus Wilmary Derry Torino.
Good afternoon, Your Honors. David Clem for Wilmary Chirinos. I ask that the court accept the people's concession in this case and grant the waiver of Ms. Chirinos' fees in the interest of justice pursuant to the recently enacted criminal procedure law 420.35 sub 2A. And although the parties have, some perhaps disputes over the interpretation or the applicability, both parties agree that this court has full authority to exercise its interest of justice powers to waive the fees. Both parties agree that the fees should be waived, and I would ask that the court does that. And unless Your Honors have any questions, I'll otherwise rest on the briefs.
Any questions?
I'm just curious, counsel, did your client pay any fees here?
No, the fees were deferred. So what this is, a judgment was entered on them. So what this would do, it would remove the judgment and permit her credit not to be impacted negatively by that.
Thank you, Counselor.
Thank you.
Next case up is Salcedo versus Sun Nation Thermal.
Good afternoon, Your Honors. Christopher Stavro, Pollock-Isaac Seagull on behalf of Mr. Salcedo. I think we have a fairly simple matter here. We have clear credibility issues on both sides, which is why plaintiff didn't appeal from the denial of his cross motion. But at its fundamental basis, it also shows the clear error by the trial court below in ignoring these fundamental questions of fact and then granting summary judgment to the defendants, even searching the record to do so. I think that's the largest issue before the court. I'm happy to address any other questions that you may have if you'd like me to dive into any more issues more specifically.
Any questions?
If not, then I'll just reserve the rest of my time for rebuttal, and thank you for your time.
Thank you. Sun Nation? Whoever wants to go first, respondents.
On behalf of defendant respondent Strathmore, Sean Burns, I am happy to answer any questions that your honors may have. Otherwise, I would rest on our brief.
I just wanted to be clear in terms of exactly what was Strathmore's role in all of this.
Sure. Well, as the lower court, in our estimation, properly found, their role was they had no role, frankly. Within the building itself, their role was upstairs renovations of several apartments that were to be rented out. There's permits that were part of the record for that work.
But they were never. Were they ever in the basement at all?
Never, and there is not as the lower court properly held, there is an overwhelming amount of evidence that we were not, or not a scintilla of evidence that we were. So no, there is nothing. We never had anything to do with the basement, the boiler, or the work being done by the plaintiff or anyone in the basement.
Thank you.
Thank you, Your Honor.
Yes, respondent.
I apologize, I was on mute. Yes, Your Honor. Kurt Gilfillan for respondents Sustainable Gemstone and DHNY. And this matter is not as simple of a question of fact as plaintiff appellant would have everyone to believe. In fact, they took 91 pages of brief to come up with enough.
So, counsel, let's review the facts.
Yes.
The plaintiff is in a basement under some pipes. He sees plumbers working on the pipes above. He says he's dismantling a boiler, and he feels something hit him. And a plumber then comes and apologizes. Isn't that sufficient to go to the jury under 240 Prens 1?
No, Your Honor. Well, Your Honor, if that were what actually happened, I would agree, but that is not what happened.
There's not a view of the record. That's what happened.
No, Your Honor. That I submit that's a fabrication of the record.
So tell me what happened.
What we have is we have the plaintiff in a basement, and look, there's an initial posit by us in a position that he was there just estimating the job that day, but we'll bypass that issue for now and get to the heart of the 240 case, which is what you're interested in. We have plaintiff who alleges he's working in basically a depressed area within the single level basement where the boiler is located. It's 2 or 3 steps down from the general basement area. At the time, he is in a crouched position, removing the exterior aluminum door to the boiler. The prior day, he alleges to have removed all of the overhead pipes. There are no overhead pipes existing on the boiler on the date of the accident. And when he says overhead, he indicated that they were eye level. So there is no one removing pipes above his head. He is crouched down. What he alleges is the day before, when he was there removing pipes, there was another crew of 3 to 4 plumbers who have never been identified who were working on the ground. Did I misread
the record? Doesn't he also say that after he was hit, someone came over and apologized? Am I misreading the record there?
No, Your Honor. Somebody came over and, according to him, said, "I'm sorry." No one said, I'm sorry, I dropped the pipe. No one explained why they were saying sorry, and I would submit that that person was never identified, and that's inadmissible hearsay.
But Counsel, wasn't there also testimony that seconds before or minutes before the incident, he also saw, or there were also individuals working on the pipes?
Yes, Your Honor.
Plumbers were working behind him at a level that was about 8 feet higher than him?
That needs some clarification, Your Honor. In that particular instance, there were admittedly, according to plaintiff, people working on that level. What is not argued in the record or brought up by plaintiff is that there is a dividing wall that separates the pit from the other area of the basement floor where the people are working. No one ever sees people, these other people, working above ground level. In fact, the record is specifically clear that these other people on page 299 of the record, that they are working on pipes on the ground. He testifies also in page 198 to 200 that the previous day these people were working on pipes on the ground. He testifies that they're working on the same project on the day in question. This is really an obfuscation of the record by the plaintiff appellant. These people are working a distance away from plaintiff, and they're separated by a wall. On page, sorry, I'll get the site, Your Honor. On page 237 of the record, the plaintiff appellant specifically states there was a dividing wall that would separate the area where the boiler was from the higher area where the other three workers were. At no point does plaintiff see what falls on him. He doesn't see a pipe on the ground afterwards. There's no noise that a pipe hits the ground. If a pipe is going to be dropped from that upper level, it would A, be blocked by the wall that he indicates is there, and B, one would hear it. Also,
it's your motion, right?
Yes, Your Honor.
So the plaintiff testifies to what he states occurred. Since it is your motion, is it not your burden to show that this is not what occurred?
I believe I have shown that. Plaintiff has not put forth any facts. All he says is that conclusorily, he was hit by a pipe. He doesn't see the gentleman carrying a pipe. He doesn't see a pipe on the ground in the boiler pit that hit him after the accident. His boss, who is with him, doesn't see or hear a pipe fall. He doesn't hear a pipe fall.
Aren't you asking us, Counselor, in essence, to sort of weigh the evidence on this issue? Isn't that because you're really making a fact-specific argument, asking us to weigh the merits of what the plaintiff says and what you think really actually happened?
Well, no, I don't think so, Your Honor. What plaintiff states is not a factual assertion, but a conclusion. What he is doing is making the leap from there were people in the basement who were doing some type of work with a pipe. That's all we know. There's no.
And we also know that at least his testimony is, and I know you say it's hearsay, but I would submit to you that at this point it probably can be considered in opposition to your motion for summary judgment if there's more evidence than just the hearsay testimony. But someone came over and apologized. It seems to me that raises an issue as to what precisely happened at the time of the incident.
If there were other supporting evidence, I would agree with you, but plaintiff appellant hasn't pointed to any other single piece of evidence. If a metal pipe fell over that wall, and I don't know how he describes it's going to have fallen over the wall, there would have been a noise. No one has to take the pipe off of him. He specifically testifies to that. So if a pipe managed to somehow get over that wall and hit him, the pipe doesn't wind up in the area and the pipe doesn't make any noise. That makes. So,
did you submit any evidence from an expert or anyone else who stated that a pipe is very unlikely that a pipe would be able to go over the wall, or that there would not have been something, some indication that a pipe had gone over the wall, or that there was no one working near there with the plumbing or with pipes?
Other than the fact that the record indicates the plaintiff testified that the people were working with the pipes on the ground, that they were not working with overhead pipes on the ground. Page 200 in the record indicates plaintiff testified that these other workers were working on pipes in the ground, and on page 199, that they were in a different area of the basement. And in fact, he goes on to say that it looks like, page 222, it seemed like they were getting ready to do a task or some kind of work that they were going to go outside and perform.
Any additional questions?
Counsel, when plaintiff sought to supplement the bill of particulars with the applicable industrial code provision, you did not respond to that. Am I correct?
You are correct, Your Honor. There was no response to that papers. I would say in response to that the court does have the ability under 3212B to search the record, and that the provision they sought to add, the 23.1.7a, is in relation to areas that are typically subject to falling hazards. And I would submit that the 10-foot tall ceiling in a basement is not the type of area. And that
but
would
generally,
be.
Haven't we said in our prior cases that that raises an issue of fact as to whether or not that is an area subject to falling hazards from above?
Under certain sets of particular facts, yes, Your Honor, that would be true. But in this instance, we have no issues that this is typically an area where falling materials have typically occurred. There's no evidence that this would be an area that would be applicable to. And additionally, there's absolutely no evidence as to not that they're just something that fell, but most importantly here, they haven't identified any argument or facts as to what failed here, that this material should have been hoisted or secured, and that there was some type of failure or absence of a safety device. There's absolutely nothing in the record to that. Simply because a pipe fell doesn't meet his burden. If there's something that falls and an injury.
Wait a minute, Counselor, it's your motion. I think, wouldn't it be your burden in the first instance to establish that issue?
Yes, and I've put forth sufficient facts indicating there's no proof that anything fell. There's no one saw.
Well, except for his testimony, the plaintiff said he believed it was metal that hit him. It was heavy. It was heavy and metal, and that's what they were working with. So,
well,
shouldn't that, at least that, go to the jury?
No, I don't believe so, Your Honor. He was working with heavy metal pieces himself down in the pit. There's nothing to say that something he had set aside is involved in this. There's no indication that the metal he was working with was different from what somebody else was working with. And there's no proof.
The metal that he was working with fell and struck him to the back?
No, Your Honor. I don't know whether he had moved into something. There's any number of scenarios, but there's no proof. There's no proof that anything fell onto him, which is the 240 claim here.
Thank you. Anything else? Anything in rebuttal?
Sorry to, if you all just indulge me. I mean, I think the first thing, I've never been accused of writing too much in a brief while also obfuscating anything. Obviously, that would not be my intention, to spend so much time diligently discussing the facts.
Well, but how do you account? Your adversary says there's a wall dividing, and it seems improbable that work being done in another room, somehow the metal pipe, if it's a metal pipe, can land on your client. I mean, it seems logical, doesn't it?
Yeah, I mean, sure. He's right to be skeptical if he wants. I mean, that's his duty as a diligent advocate for the defendant. But skepticism as to the occurrence of an accident doesn't render it a question of plausibility, one that has to be determined by the court. Your Honor is correct in noting that he's asking you to weigh the evidence and say that something is incredible as a matter of law, and to draw an inference in his favor when an inference can be drawn just as easily in the other. He's also ignoring that it wasn't just plaintiff's testimony that there were workers there. It's also Mr. Hernandez, who they try and rely on to carry
on the date of the accident. Who was there on the date of the accident? Was plaintiff, who else from plaintiff's side? Was Hernandez there on the date of the accident?
Yes, Hernandez was there, and then he eventually said that there's someone else named Gomez who was there. Plaintiff testified that there's an engineer who came and gave him instructions as to safety and who walked away. And there were numerous contractors. Hernandez said that there was lots of contractors there at the same time. That was at page 785 to 786. He also said that there are contractors working on the hot water system. Now, it's also inaccurate to say that the plaintiff was the one who is dismantling all of the pipes in the basement. He was just dismantling the couplings that to the actual hot water heater. Now, one thing that I'd like to address with respect to Strathmore is I don't think it's fair on this record to say that they had no role. At no point can Mr. Markowitz testify even who paid the only plumber that exists on this entire record.
But your adversary's point on that issue is that they were working, as my colleague brought out, they were working on the apartments above. Any evidence that puts them down in the basement?
Yes, there's two pieces of evidence that puts him down in the basement. The first is that at the workers' compensation hearing, he specifically testified that when Caney, who is the only boiler contractor on the case, asked for help, Markowitz supplied him with materials. That's at page 890 to 891 of the record. He can never say for certain that it wasn't him who, pursuant to all of the documentary evidence, is the only general contractor identified on this project. That's the first piece of evidence. The second piece is that he specifically states that he went into the basement to inspect the work after it was completed. I don't know why he's inspecting the work after it's completed if he has no role in supervising how it's done. He doesn't say he was doing it in his capacity with DHNY. He doesn't say he's doing it with his capacity as Gemstone. He's just completely nonspecific. And now I understand, and the plaintiff even said in their papers below, if there's definitive proof that Strathmore was not involved in this project, we will withdraw the claims against them, just as they withdrew the claims against Sun Nation. They have no interest in pursuing a claim that's not well-founded. But the problem is he can't testify or give a straight answer as to the comings or goings of any of the different entities he's involved with. And that may be because there's way too many other people involved in both Gemstone and DHNY, but that may be something that we work out after the fact. The point is that on this record, Strathmore cannot point to and carry their burden that they had no involvement with this project. That's the problem.
Thank you.
Thank you, Your Honors. Have a great day.
Thank you all. The next case is Tawari versus the City of New York.
Good afternoon, Your Honors. May it please the court. My name is Julia Quigley with Kramer Levin, and I'm pro bono counsel to Mr. Krishna Tawari. The city imposed an unconstitutionally excessive penalty on Tawari, and today we ask the court to strike it down. He was issued a $6,000 penalty for failure to get a permit for the sign on his small shop in Cypress Hills, Brooklyn. And the excessive nature of the penalty was demonstrated by the city council.
Ms. Quigley, I'm sorry, Justice Shulman. There's no dispute that your client installed a 4-foot by 20-foot cantilevered awning with the electric light part without a permit, correct?
Correct.
And that is a clear violation of the applicable administrative code.
Correct.
True. And at the time this violation occurred, the penalty component of it, which would arguably allow them to impose a minimum of $6,000 up to a maximum of $15,000, was in place, correct?
Correct.
So under those circumstances, he didn't get the highest fine, he got the lowest fine.
That's correct, but this penalty applied to any building other than a 1 or 2 family residence. So it would have applied to Trump Tower, One World Trade Center, and his bodega. I understand that he received the minimum penalty, but the scale is just so far off balance. And furthermore, he wasn't kind of meant to be a target of the law, and that's clear from the legislative history that this was really meant to combat tenant harassment through construction. And it's just the penalty kind of doesn't fit his crime.
Couldn't it be argued? The argument is that it's excessive because of his own financial situation.
That's one of the factors that courts consider. in addition to the severity of the harm and the seriousness of the offense. As we point out in the brief, he runs a small bodega in Cypress Hills at a time when small businesses are really struggling to compete against the Amazons of the world, even without a $6,000 penalty from the city. So yes, it was a burdensome fine for him.
Well, this was in 2012, so I recognize that Amazon was a giant, but still, we're talking about 2012, and he did construct it. So, I mean, what should the court also looked at the purpose of the legislation in terms of what the awning, the effects of the awning?
Your Honor, so the awning was constructed in 2012, and he received the penalty in 2018. Just to be clear. And yes, I think evidence of the penalties, unconstitutionality and excessiveness is really made clear in the Awning Act, which was Local Law 28 of 2019. And so this law specifically repealed penalties for signs, exactly like Mr. Tewari. It waived all outstanding penalties issued after December 2017, which Mr. Tewari's penalty was issued after 2017. The only reason the law didn't apply to him was because he conscientiously paid the penalty in order to file a certificate of correction.
Didn't the city council, I'm sorry, excuse me, didn't the city council consider that? And I know it's in the record that there was the possibility of individuals like your client being able to seek reimbursement of paid fines, but that was not in the final bill version. Am I correct?
Yeah, that's correct. And it was the city's prerogative to decide to do that. I still think the legislative history of the act really shows that it was an excessive fine. As Council Member Menchaca put it, a civil penalty of $6,000 is incredibly exorbitant. Council Member Espinal also stated the $6,000 civil penalty combined with the new price tag of a new sign can be devastating. And the whole reason this legislation repealing this provision was enacted was because it was so burdensome on small business owners in the outer boroughs, which that's what Mr. Tewari is.
Thank you. Yes, City?
Good afternoon, Your Honors. May it please the court, Amy McCampbell on behalf of respondents. Your Honors, I'd like to start with some of the most glaring deficiencies of Tewari's claim, namely his inability to show that any of the factors that courts consider in excessive fines jurisprudence support his claim. And most glaringly, Mr. Tewari has not shown and cannot show that his economic circumstances support a finding of an excessive fine. Mr. Tewari claims for the first time in his appellate briefs that he is of modest economic means. He did not raise that contention below in his ECB proceedings. He did not raise it in the Article 78 proceeding before the Supreme Court. And for that reason, this argument is entirely unpreserved. Moreover,
well, the fact that he argued that it was excessive, does that not, would that not also encompass an argument that financially he was unable to pay it? And also he talks about the moratorium. Would that also not lead to some conclusion that he was making an argument as to his financial status?
Well, Your Honor, in the street vendors case, this court denied an excessive fines clause claim because there was nothing in the record to speak to the particular circumstances of the petitioners. And that's exactly the case here. Moreover, to the extent there is anything in the record regarding Tewari's financial circumstances, it supports the opposite inference. We have the deed to his bodega building on page 65 of the record, which shows that he purchased a 1 to 3 family building with a store and office space in 2011 for over $500,000. That's on page 71 and 72 of the record. So because Mr. Tewari cannot show and has not shown that he is of limited economic circumstances, that alone is fatal to his claim because that's one of the factors that this court considers. And again, that was the basis of the denial in the street vendors case. The other factors don't support Tewari either. Tewari argues that this was that his offense was not severe and that there was no potential harm, but there is a palpable harm both in the construction of the awning, which was unpermitted, and therefore the safety of the contractors cannot be assured, and there could be harm to the public because this is overhanging a public thoroughfare where people walk on the sidewalk all the time. This is just like the Stefanos case, in which the Second Department upheld fines of over $40,000 for unpermitted building work. Now, Tiwari characterizes the work in that case as grave offenses, but he fails to show how that unpermitted work, which was a deck and garage, is any different than his unpermitted work, which is an electrically illuminated storefront awning. And I'd also just like to address the points that Tiwari raises in his reply brief. This court made clear in the Prince case the difference between a punitive fine, which is subject to the excessive fines clause, and a non-punitive fine, which is not. And this court clarified that punitive fines are associated with complete bars on certain activities, whereas non-punitive fines are associated with requirements that those activities be performed in accordance with regulations. And it's very clear exactly what type of fine and regulation this is. Mr. Tiwari was not prohibited from installing an awning, but he was simply required to do so in accordance with the DOB permit, and he did not. And the fact that this fine has a deterrent purpose does not make it punitive, as this court's holdings in the OTR Media Group case and the Franklin Street case also show, Your Honors. And finally, Tiwari's point in his reply brief that the Bajikagian case conflicts with this court's precedent is also incorrect, because in Bajikagian, the federal government conceded that the fine there had punitive purposes. There was a over $300,000 civil asset forfeiture for a single currency reporting violation. And in the OTR Media Group case and the Franklin Street Realty Group case, again, recent decisions from this court, there the fines were purely deterrent. The courts held that they were intended to coerce compliance, and for that reason, the excessive fines clause was inapplicable in the first place.
How do you address your adversary's argument concerning the subsequent moratorium on the fines?
Sure, Your Honor. So the City Council considered providing refunds to parties like Tiwari, and the final enacted legislation did not include a provision for refunds. So the City Council clearly did not think that the fact that Mr. Tiwari can't get a refund for his fine is so unfair enough as to justify any legislative relief. And therefore, Tiwari's argument that the temporary moratorium shows that the City Council itself thought that this fine is unfair is simply unsupported. The City Council did not reduce the amount of the penalty. In fact, just a few years ago, it raised the minimum penalty from $5,000 to $6,000. It merely put in place a 2-year enforcement moratorium that happened not to include Mr. Tiwari.
Thank you. Any questions? Thank you, Counsel. You have, I believe, 1 minute in rebuttal.
Thank you, Your Honor. With regard to the question of Mr. Tiwari's circumstances, this wasn't raised in the ECB hearing because the ECB hearing was solely on the underlying violation under 28-105.1. This has been his first opportunity to make any statements about his economic circumstances. And when it comes down to it, he's a small business owner. I'm not sure if there's a mortgage on the property, but he's a small business owner operating in Cypress Hills, Queens.
Counsel, wouldn't it have been incumbent on you if you are going to assert, in fact, that the fine is excessive in part because of economic circumstances, to lay it out, as opposed to there's evidence that he owns the building, right? So that does make that questionable, no?
Right. I think the economic circumstances question, it's a continuum. So there are developers who are concededly billion and multi-billion dollar developers. Mr. Tiwari is not that. I think I'll
agree with that statement.
Thank you, Your Honor. And with regards to the 4 factors that the court have laid out, there's undisputed evidence in the record that the sign was secure. The licensed sign hanger who removed it attested to that in an affidavit. And any argument that the city has that these signs pose an imminent danger really fails when one considers that these violations were essentially repealed by the Awning Act. And so clearly the City Council didn't think that these provisions were critical to keeping the public safe. And with regard to Council's point on the distinction between a remedial fine and a punitive fine, the idea that a remedial fine is tied to the requirements or a remedial fine is one that must be performed in accordance with applicable regulations. This just contradicts the Supreme Court precedent in Bajikagian. In that case, a man traveled internationally without $300,000 without declaring it. There's not a ban on traveling with $300,000. You have to declare it. You have to comply with regulations. So to the extent there's contrary language, in other cases, that's just incorrect. And then again, with the idea that a remedial fine is intended to enforce compliance, if that were true, then I can't really think of many fines that would be subject to the excessive fines clause. And in Bajikagian, the court specifically noted that deterrence is a traditional goal of punishment. And even if a fine has a remedial component, if it has a punitive element to punish, to deter, then it's still subject to the excessive fines clauses.
Thank you, Counselor. Thank you very much. Next matter up is Barber versus A.O. Smith. Appellant on Barber. Apparently you only come in after the case has been called. Are we here yet? Oh my gosh. So as soon as I call the next case, then he'll come in, right?
Probably.
Mr. Weinstein, you're here, right?
Yes, Judge.
I got to come back to you. Sorry about that.
I understand, Your Honor.
Okay, we'll come back to you. Star Indemnity versus Monte Carlo.
Good afternoon, Your Honor. Counsel Ariel, may it please the court. This appeal asks the court to consider the legal significance of an ambiguous question on a written application for a policy of commercial property and casualty insurance. Question number 9 on Accord Form 125 cryptically asked Dorchester any uncorrected fire code violations. Dorchester's carrier, Star, sued Dorchester to rescind the policy, claiming that Dorchester made a material misrepresentation in the application. The legal issue on this appeal, on Dorchester's appeal, is whether Justice Sherwood, the motion court, correctly found question number 9 to be unambiguous as a matter of law.
What's the plaintiff's interpretation as to the meaning of question 9?
You mean Star? Star is the plaintiff.
I'm sorry. Your client's interpretation, the defendant's interpretation.
Mr. Mott's interpretation, he was the applicant. He put in an affidavit on this issue. It's pages 1686 of the record. His interpretation of this question was that it required notice, opportunity to cure, and failure to cure within a reasonable time, resulting in some kind of enforcement activity by the fire marshal, like an appearance ticket or a summons. The question on this appeal, Your Honor, is not necessarily whether that interpretation is correct, but whether it's rational or not. If you look at Garcia and Fanger and Nadell, the standard is whether the insurer's interpretation of the question was rational or not. And if you look at Mr. Mott's interpretation, it most closely matches John Ustaglu's interpretation, the underwriter who bound this particular policy for Star. I'm sorry, Your Honor is on mute.
Justice Singh, you're mute.
The plaintiff's witnesses, I think there were 5, and they have 5 different interpretations here. So we have a total of 5 or 6 maybe reasonable interpretations here of what this provision means?
That's exactly right. And the definition of ambiguity is whether a policy provision or a provision in a contract is reasonably susceptible to more than one interpretation. And you have 3 witnesses, Star produced itself, who disagreed about what the question meant and disagreed with each other about what the question meant. John Ustaglu, like Bradford Mott, testified that the question meant notice, reasonable opportunity to cure, and then failure to cure. Richard Alexander, Star's executive, who Star actually produced as its corporate representative, he testified as Star. He testified that he read Mr. Ustaglu's deposition testimony and he disagreed with it. Mr. Alexander's interpretation was that the question required neither notice, nor opportunity to cure, nor failure to cure within a reasonable time. It didn't even require awareness on the part of the insured that there was a condition in the building. He said that the insured had a duty to disclose a condition in this building, whether or not the insured was aware of it or not. So for Mr. Alexander, the question required omniscience. The third interpretation by Star's own witness was John Margreaves, Star's third-party claims administrator, the adjuster who recommended to Star rescinding the policy. He testified that it didn't require notice from the government or an opportunity to cure or failure to cure within a reasonable time. He said that it required knowledge by the insured of the existence of a condition in the building, which, if observed by the government, could result in the issuance of a citation for a fire code violation. So you have this third interpretation. It inherently conflicts with Mr. Alexander's and Mr. Ustaglu's. And the only question on ambiguity is whether it was susceptible to one or more reasonable interpretations. And here you have three from Star itself. Now, Star argues in its appeal papers that a policy provision or a contract provision isn't ambiguous just because the parties disagree about its meaning. This is not a case where two parties to a contract disagree about a meaning. This is a case where the same party who produces three witnesses internally disagrees among itself. Star was schizophrenic about the meaning of this question on the application. And the only question is whether Mr. Mott's answer was reasonable under a rational construction thereof. Mr. Mott's construction of the question was rational for a number of reasons. He believed that if I had failed to correct a condition, I would have been issued a summons or an appearance ticket. That construction is supported by the language of the citations the fire marshals issued themselves. If your honors look at the very bottom left-hand corner of the citations, there is a penalty provision. And it says, in effect, failure to comply with this order is a misdemeanor. Mr. Mott knew when Dorchester submitted the insurance application on October 18th, 2012, Dorchester had never been summoned. It had never been issued a appearance ticket. That's undisputed in the record. The second reason why Mr. Mott's construction of the question was rational is this is not a case of an insured who received citations and simply ignored them. There is a mountain of evidence in the record showing ongoing compliance activity over many years. And I would just refer the court, if it is looking for the most concise, packet of evidence, it's pages 1697 to 1710 of the record. That lists in 13 pages everything Dorchester did to comply with these citations. It's also pages 12 to 28 of our reply brief. Mr. Mott knew when he submitted this application that Dorchester bent over backwards to comply with the fire marshal's wishes. And the fact is the fire marshal lost paperwork. It didn't follow up. It didn't do the things it was supposed to do and left Dorchester in the lurch. But Dorchester knew at the time it submitted this application that there was a longstanding demonstrated track record of compliance activity. And based on that, it was rational for him to conclude that if I was not in compliance, I would have been issued some kind of appearance ticket or summons. The third reason why Mr. Mott's interpretation was rational is because his interpretation of the question most closely matches John Ustaglu, the underwriter who Star admits at page 9 of its respondent's brief, his interpretation of the underwriting guidelines is binding upon Star. You put that all together and you have an insurance application question that is ambiguous. And Mr. Mott, when he construed it, could have rationally construed it to require the issuance of an appearance ticket or a summons for him to have had any uncorrected fire code violation at his building. And by the way, Star did not even attempt to argue anywhere down below or again in its appeal papers that Mr. Mott's interpretation was irrational.
Counsel, what I don't kind of understand is if you're applying for fire insurance or insurance, right, for coverage for fire, and you have these prior instances where there have been potential violations because you've done something that you should not have done. Is that not something that the insurance company would want to know? Because otherwise, would it not be that you can engage in this conduct, you rack up these violations, and you continue to rack up these violations, but you correct them? Isn't that something isn't that kind of like a pattern of behavior that the insurance company would want to know, and therefore that would be the basis for this question?
So whether the insurance company wants to know it or not, that relates to the question of materiality. And Justice Sherwood concluded that Dorchester raised a triable issue of fact on the issue of materiality. There are 4 instances in the record of insureds answering yes to this exact question, and the insurance company writing the policy anyway. Now, the issue of materiality is not up on appeal here. Starr did not brief the issue of materiality. Justice Sherwood ruled that that's an issue of fact for the jury. The court shouldn't touch the issue of materiality, but if the court is inclined to consider it, there's enormous evidence in the record that the answer to this question was immaterial. And if Dorchester had answered the question yes, Starr would have written the policy anyway.
Thank you. Any other questions? Thank you.
Thank you.
Yes. I'm sorry, yes. Charlie, yes.
Yes, no, I represent, my name is Lauren Bristol. Good afternoon, Your Honors. I represent the plaintiff responding cross appellant, Starr Indemnity and Liability.
I apologize. Thank you, Ms. Bristol.
That's okay. So on the issue of ambiguity, the lower court properly determined that question number 9, which says any uncorrected fire code violations, is not ambiguous.
Ms. Bristol, can I stop you for a second?
Absolutely.
That's not even a sentence, correct? It's just a part of a sentence.
It's a question.
Would you agree that it's not a sentence? It doesn't contain a verb. You know what we learned back in English when we were kids? And wouldn't the question have been easier to answer?
I think that this form is an Accord industry standard form. It is designed to give the question the most direct interpretation as possible.
Yet, I think there are 3 witnesses, maybe with 5. There are 5 different understandings as to what that question means.
Well, first of all, if we look at the question itself and we talk about the fact that this is a application for a multi-million-dollar fire insurance policy, asking if there are fire code violations is directly would be within the contemplation of what an experienced real estate person or entity that's applying for the insurance would be requesting. If we need to go to extrinsic evidence, which I don't think you need to, if we look at the testimony that's
so it's your position that there's no ambiguity at all. I mean, that's
there's no ambiguity at all. But if you would permit me to address as to say Bradford Mott, his testimony, it's self-serving, and I know that counsel just brought up the fact that when you get an order, it says in bold print across the top, all capital letters, that this is an order to remove violations forthwith. There is no ambiguity there. They are violations. And what you have in that lower left-hand corner says, if you don't fix those violations, then you are going to be charged with a misdemeanor. This insurance application doesn't care whether you're charged with a misdemeanor in that respect. It didn't ask if you're charged with a misdemeanor. What this does is it is allowing the insurance company to make a decision about whether or not they can see what the risk is, what the exposure is, whether or not they're willing to undertake this kind of risk and exposure. And clearly, knowing whether or not there's a fire code violation is a direct question that should be answered when you're asking for a residential apartment building, multi-million-dollar fire insurance policy. are there uncorrected fire code violations? It couldn't be more direct than asking it that way.
If it's so clear, why is it that your witnesses have a different understanding of what this question means?
Well, that's a bit of a misnomer, because all of the witnesses said, what does this question mean? This question means, are there uncorrected fire code violations? They all acknowledge that that's what it is. When you look at John Usaglo, he specifically said, he's the one who'd be underwriting that policy. He said a fire code violation that hasn't been corrected. But when you look at it in terms of questioning by plaintiff's counsel, they were asked questions almost in a legal sense, because this is a case that underlying this case obviously is the material misrepresentation. And as we know, in a material misrepresentation, you don't have to have knowledge of the fire code violation, right? It can be innocent. So that's how material misrepresentations work. So when the questions are being asked of these individuals from STAR, they really are looking along the lines of not just what this question is, but what's this question in the context of you asking for rescission, you asking if there's material misrepresentation. So that's not fair in that respect to say that their testimony was different. You even have taking Mr. Usaglo's testimony and cross-examining Mr. Alexander directly on that. And that in and of itself makes for, let me see if I can make the ambiguity, because if I can make the ambiguity, then I can make this go away. So that testimony shouldn't be looked at because you can ask, 10 other, 12 other, 15 other people, and then keep going, well, what else could it mean? And that's not what that's about. What we have here is contract interpretation, and that's what we need to look at here. We need to apply contract interpretation, which is what is the reasonable expectation by the insured employing common speech. And we know that the insured here it has to be forthcoming on correct information, because the insurer needs to make an informed decision. There's no contract yet. This is a proposed contract, and both sides need to decide whether or not they want to accept this contract. So this is not to be used where you use the application of a standard for an exclusion to the policy, because that wouldn't be appropriate. Because under an exclusion to the policy, you're going to look at it in favor of the insured, not the insurer. In this case, it's a back and forth, because we need to know what exactly is going on. We're going to, as STAR is going to insure these residential properties. There were 11 that were involved in this case. We know of 3 of the properties that have fire code violations that have been issued. We know we have a real estate entity that's applying for the insurance that since 1998, since owning 9-17 St. Paul's Road, has had an enormous amount of fire code violations between 1998 and 2012. He clearly knows what a fire code violation is. Even testified that, I have an attorney that helps me with my fire code violations. And this policy.
So are you saying that these prior fire code violations would somehow play into how he saw that question, or how he interpreted that question?
Yes, in the respect of the fact that we have to put it in context. So if we're using standard contract language and we're using the plain meaning and the expectation of the insured when they're reading this isn't like the life insurance policies like in Fanger and Nadell and Garcia, where you have individuals who are answering information about their medical. This is a sophisticated real estate entity that has been in the business for a long time, that knows it's looking for multi-million-dollar coverage. I mean, just those 3 properties alone with the fire code violations amounts to about $23 million worth of property damage coverage. So you have, yes, in that respect, the answer is yes, that it does factor in the sense of whoever is looking at this Accord 125 industry standard insurance application has seen this before. It's used standardly in the business. And yes, it wouldn't be, somebody who's applying for life insurance answering that question. It would be somebody that already has the sophistication. And so you want the insurance company to know the right information to make a decision about whether or not to issue the policy. I did want to mention the fact that
you have 1 minute.
Okay, I did want to go on to the fact that summary judgment should have been granted to Star Indemnity. We take issue, if you read the order, it's our position that Judge Sherwood decided that materiality was found in our favor, that the question itself was material. We put John Ustavla's testimony in. PJI Commercial was the entity, and he was the person to make the decision. He said it based upon the application. And if you look at that order, the two orders issued on October 11th, 2012, they're 1 week before the application is filed. And all of those say that this order to remove violations forthwith is in place. In addition, if you want to just look back at the testimony of Mott at page 1689, where he says in an affidavit, in the same type of order, same type of order in January of 2008, he says, I paid my fee, I made the application, and I hired somebody to do the work for me to rectify those violations. And when you look at October 11th, 2012, in this record, you have just the application and the fee. There's absolutely no evidence in this record that any of those violations on those pages that are set forth in 226 and 225 were ever fixed before this application was signed. These violations were still outstanding when he signed the application on January 18th, 2012.
Thank you. Mr. McRoberts, you have 2 minutes on rebuttal.
Thank you, Your Honor. I would like to respond to something Ms. Bristol said. She attempted to ask the court to apply a sophisticated business person standard to interpretation of this question. She referred to Dorchester as a sophisticated real estate entity. That is not the legal standard for determining ambiguity. And Starr makes that point at page 35 and 41 of the respondent's brief. It cites a Court of Appeals case called Cragg, which says insurance contracts have to be construed in accordance with the reasonable expectations of the average insured. It's not a sophisticated insured or sophisticated business person standard.
But would that not go to the rational basis or how the question is actually interpreted? If this is an industry-wide form and an industry-wide question on these forms, and your client is in the industry, meaning having properties wherein he's sought insurance, would that not go to how he would interpret or understand that question?
The standard is what a reasonable person in the insured's position would have thought viewing the application and whether their interpretation was rational or not. So I don't think Mr. Mott's sophistication weighs into whether this question is ambiguous or not. You look at it objectively. And there's something, I would just say, fundamentally counterintuitive and illogical between three witnesses for the same insurance company fighting amongst themselves about what this question is supposed to mean, and Justice Sherwood concluding that this question was subject to only one reasonable interpretation. The facts in Justice Sherwood's holding, they cannot be reconciled with one another. This question was ambiguous as a matter of law. And if it is ambiguous, it's game over for the insurance company. The insurance company the court does not even need to get to the issue of misrepresentation. The one thing I would add, too, is that the Court of Appeals has held that a question can be ambiguous in one context and not another. And the Second Department last year ruled in a case called Liang that a question was ambiguous under the circumstances of that particular case. We're not asking the court to invalidate Accord question number 9 for the industry. It's ambiguous the way Starr interpreted it here and the way it tried to force it to rescind the policy here.
Thank you. Any other questions? Thank you both. Thank you very much. Barber versus A.O. Smith.
Good afternoon, Your Honor. My name is William O'Connell, and forgive me again for all the technical problems. I'm counsel for Kohler Company, the defendant appellant in this appeal, and this is a fairly straightforward CPLR 3211A8 motion to dismiss that the court never addressed on the merits. It found a procedural waiver and denied our motion. The 17th affirmative defense in our answer, which is a standard answer that was filed back in 2012, stated, where applicable, defendant preserves its right to object to personal jurisdiction of plaintiff over defendant, end quote.
So, counsel, how did that give the plaintiff notice that you were challenging this state's exercise of long-arm jurisdiction? How did you put the plaintiff on notice of that, just by what you said?
Well, I think by the use of the terms personal jurisdiction of plaintiff over defendant, obviously stating that, that's putting... Is
that even a correct statement? Is that a correct statement of the law?
Well, it is a correct statement of law as I understand it, when the standard is to construe pleadings very liberally and that defects should be ignored if there's no violation of a substantial right. And respectfully, Justice Mendez did not follow that standard. And he relied on a decision, a 40-year-old decision from the Second Department that's not controlling here. And a Court of Appeals case decided 3 years after essentially negated the analysis from Walden. I mean, CPLR 3026 is a statute, and it says pleadings should be liberally construed and defects ignored if a substantial right is not prejudiced. The phrase used, preserve, is awkward. I completely concede that. But it's also, I was reviewing the case Galloway today from the First Department, which is an older case, but it also said, quote, 3211E permits a defendant who objects to jurisdiction the right to preserve such objection by asserting an affirmative defense in the answer. Now, unfortunately, counsel who drafted this standard answer may have misunderstood what that meant and used the preservation language. But in truth, the purpose of this rule is to put plaintiff on notice that there could be a jurisdictional challenge. And that's what this did. We said that we're preserving a challenge to jurisdiction. Preserving means to save or to retain, not to relinquish or to give up. So as far as notice, I don't see that as a valid argument here. Walden addresses the different question, and that's a question of where in the answer there's one defense asserted, and then in the motion to dismiss it's a different defense, particularly if they're unique or specific. Obviously, arguing one in the first would give nobody notice of the second, but that's not what happened here. We asserted
counsel, there's also controlling authority in this court that a jurisdictional defense must be pled with specificity, and this wasn't done here because you say in your own brief that it can be read to challenge service of process or long-arm jurisdiction. There's nothing
Your Honor, the
specific
standard as I understand it under the CPLR is sufficient particularity. However, the Court of Appeals in Rich, which is the controlling authority in this case, certainly over Walden, an older Second Department case, said that in that case, the argument was that there was a failure. The first, it was a malpractice case, excuse me. And the argument was that the person was not personally served. And then in the motion dismissed, they said there was no nail and mail substitute service. And the court said, well, that it wasn't unduly unspecific. The broader one necessarily implied the more specific defense. The plaintiff had a remedy to move for several years, and the plaintiff had the remedy here. They could have moved for a more definite statement. We had depositions, we had interrogatories, all of which clearly were focused on long-arm jurisdiction. So the idea that Weitz and Luxembourg really thought that this meant process is just, I don't find that credible. To be honest, obviously, if you were making a process, the CPLR requires you to move within 60 days for that, and that was not done here. And the whole focus of discovery was product identification, work sites, and in our view, the New York Forum, whether my client, Kohler, is from Wisconsin, and the only connection ever in any of the evidence was that he was subjected to asbestos from Kohler in California. So that's why the motion would have merit. And it was awkward wording. I'm not going to deny that, and it's unfortunate that it was. But in the context of a standard answer under the NICAL system, where we have to make pleadings, and the plaintiff has to make pleadings that apply to a broad variety of cases, and in this case, a preservation language was used because at the time, at our answer, we don't have any of the information about contacts, so we can't. Now, a more seasoned attorney, maybe somebody who drafted this answer said, you just say there's no jurisdiction, but in this case, they said we preserve that. Still, Whites and Luxembourg knew that jurisdiction was being challenged at that point, and while they could have had better information, the Court of Appeals in Rich said, the plaintiff can also move for that. We're moving away from rigid formalism of pleadings. And as far as I know, Rich is still good law, and unless there's
excuse me, Counselor, I'm reminded that I think I sat on another asbestos case wherein the language was similar in terms of jurisdiction. That was matter of New York City asbestos litigation. That was a case I sat on in 2019. Where the complaint, you were attempting to establish a basis for general jurisdiction, and you stated to the extent that it is a duly organized foreign corporation doing business in New York. And we held that that was insufficient. We said that it could not be have worded, that you could not have worded the language in terms of constituting or contesting general jurisdiction. So it's the same thing in terms of the lack of specificity in your pleadings.
Well, Your Honor, I would argue that case was slightly different. I think it was Gibson was also the name involved in the case. And that was an instance, unlike affirmative defenses, that was an instance where they were relying on the allegations, what was denied, specific denials in the answer. And in that case, the defendant denied the allegations as to specific jurisdiction and did not deny them as to general jurisdiction, and actually did admit that they did business. And under pre-Bauman law at the time, that would have been enough for general jurisdiction. So that was a case to find that they essentially, by their own pleading, admitted to general jurisdiction. That's not this case. This case, the wording was not what I would choose to put in my standard answer, that's for sure. But having it was done, it was a general objection, preserving objection to all jurisdictional claims. And again, in Rich, if you look at Rich and compare it to Walden, Rich is the Court of Appeals case. It's not that different, and it's not that different from this case. And the Court of Appeals in that case said that that's not the general assertion of the defense of lack of jurisdiction essentially necessarily implied the more narrow one, and that the plaintiff had ample opportunity to move for a more definite statement of the pleading, and that we're moving away from this. We're not going to go gotcha and say, okay, well, that's a poorly worded affirmative defense. In this case, we asserted it. I believe Whites and Luxembourg knew that they were subject to a potential challenge depending on what discovery showed. And in many of these NICAL cases, it takes several years, and we cite some of them in our brief, where it takes 2 or 3 or 4 years down the line before we preserve it in our answer and we make it. Now, maybe it was just a moment of candor where the person who did it said, well, I can't say we don't have jurisdiction because I don't know yet. But under a liberal construction of pleadings, I don't think that's a basis to waive a defense, and that's our position.
Any other questions? Thank you. Mr. Weinstein?
Good afternoon. First of all, Your Honors, let me distinguish the Rich case on a couple of fronts. Number one, in the Rich case, the specific affirmative defense at issue was in the realm of service of process. And what happened then is that on the motion, it was a different type of motion made, again, service of process. What we have here is obviously an affirmative defense which addresses service of process. And then we have a motion made with respect to general or long-arm jurisdiction. That's the first way it's distinguished. Second of all, what you had in Rich was a very broadly written affirmative defense. And then you had a motion that was made that was specific. And so what the court simply said is that the broad affirmative defense, the general affirmative defense, would encompass various specific types of motions. What Judge Kennedy said was perfectly correct in terms of this court said in Interlink that a defense based on a lack of personal jurisdiction is deemed waived if the defendant fails to assert it with specificity in its answer or in connection with a pre-answer motion. And in fact, here it was stated in specificity, but not as to general or long-arm jurisdiction. There's been no court from the First Department to the New York Court of Appeals to even the Supreme Court, which has referred to general and long-arm jurisdiction as jurisdiction of the defendant over the plaintiff. It's
What
never.
does that mean? What does that mean to you?
It means service of process. That alone, even written that way, would take it out of the realm of general or specific jurisdiction, except as kind of a double whammy against the defendant here, that actually specifically refers to something else. Looking at all of the cases which address an affirmative defense having to do with service of process, it's always stated as a plaintiff obtains jurisdiction over a defendant by making proper service. So the way that that defense was written, it specifically pertains to service of process, not to general long-arm jurisdiction, which was the motion made here 4 years after the fact. Barring any further questions, Judge, I'll rest on the papers.
Your Honor, 30 seconds rebuttal.
Yes.
The basis that counsel is trying to distinguish Rich is not accurate. There was no service of process jurisdictional defense alleged here. It's not mentioned. His research into cases that talk about plaintiff having jurisdiction over defendant, I could probably find 10 that say the opposite, and I believe I wrote one in my reply brief that included that language, but it was not. So there's nothing about service or process in this case. This was a general, poorly drafted, standard affirmative defense that said we're preserving our right to assert a lack of jurisdiction over the defendant. And later we moved based on long-arm jurisdiction, which everybody in the world knew is the type of motion that's being made here in these asbestos cases. And certainly all the counsel at Weitz and Luxembourg know that. And so he's just trying to fit it into.
You continue to say, well, they knew and everyone knew and Weitz and Luxembourg knew. But is that really, is that the test? I mean, is that what we should be looking at, what they knew or what they should have known?
Well, Your Honor, I guess I'm taking a liberty given their reputation and as very good asbestos and experienced asbestos counsel. But what we really should look for is what did this put notice, what did it put plaintiff notice on? And respectfully, there's nothing mentioned in there about process or suggesting process, although counsel in his cases says there is. My position is the language itself does not suggest. It suggests a general preservation of a right to attack a lack of personal jurisdiction, and that's done in the answer, and it's preserved because they have no information to do that, and it takes many months, if not years, of discovery. And it was poor language, but it should have been. It's a general assertion. It's not a question of using one and then you're waiving it because you didn't bring up the second one and you tried that in your motion. We didn't do that. The first one is a general one, and I'll rest on that, Your Honor.
Thank you. Any questions? Thank you very much, Counselor. Thank you both. Itruria Ventures versus Provident Bank.
Your Honor, he's on mute.
Who is it?
Mr. Rossi, Ron
Oh.
R.
I don't even see him. Mr. Rossi? It's not showing up on my screen.
Yes.
Oh, There you go.
My apologies.
Quite all right.
Good afternoon, Your Honor. This is Mr. Rossi for the appellant, and this appeal involves two causes of action. I want to focus the argument, to the extent the court is inclined, on the first cause of action, the fraud cause of action. That fraud cause of action, in its first iteration, was dismissed in the trial court. It was dismissed because the allegations were essentially that a broker, in this instance my client Biz2Credit, had passed along information from a borrower to a lender, and as a result of that was not duty bound under any circumstances to attest to or otherwise support the veracity of the information it was passing along. In that first iteration, it was alleged that the broker knew that the information it was passing along was in some instances false. In dismissing the cause of action, Justice Barak indicated that if it could be repled such that it could be demonstrated that there was active lying, I believe the term he used, then the cause might be sustainable at a pleading stage at least. Respondent repled the cause of action, and it was upheld. The reason it was upheld are erroneous for several independent reasons. The first is that the court effectively concluded that by taking the word concealment and putting the word active in front of it, the acts of Biz2Credit and passing along the information all of a sudden became something that was actionable instead of not actionable as an omission.
Counselor, this is Judge Singh. You talk about the distinction involving typical broker cases passing on information to the bank. But in this instance, isn't there a distinction to be drawn where allegedly Biz2Credit knowingly passes information that it knows is false to induce a loan that it knows that will benefit its affiliates? Now, isn't that a distinction that we should consider here?
Actually, it's not a distinction that this court should consider with respect to the conduct of Biz2Credit, because I think to consider that distinction will create a dangerous slippery slope in the absence of a duty to disclose. The very nature of not having a duty to disclose when you are talking about a fraudulent omission is that you necessarily accept that some level of material information, which is known to the person who does not have the duty, will not be disclosed to the recipient of that information who otherwise would have benefited from it in whatever calculus it or he or she is making with respect to whatever they're transacting. That's the very nature of a fraudulent omission. It's the fundamental distinction between fraud by omission and fraud by commission. All that the repleading did was dress up this notion that by knowing they somehow had a duty to do something affirmative. But the thing they were passing along was someone else's affirmative statement. And so unless and until there's a duty that can be established that would have required Biz2Credit as the broker to essentially disclose what it knew, but was under no duty to disclose.
So in other words, the broker knows that it's false information. The broker knows that if a loan is procured based on this false information, that its affiliates will benefit, that there's some sort of safe harbor, and there can't be the broker can't be held or Biz2Credit can't be held liable for fraud.
Absent a duty that exists between it and, in this case, the lender. And there is no duty in the record whatsoever. And there's not even allegations that would give rise to a duty. They haven't tried to argue, for example, that because they were armed with the knowledge, they somehow then had a duty, notwithstanding the normal relationship between a broker passing along information from its client to the potential lender in this situation. And so as harsh as it sounds, that's how the law is, and that's how the law has to stay, because unless there is a duty, you are allowed to not disclose material things. That's the fundamental precept of fraud by omission as compared to fraud by commission. The only fraud by commission here that is alleged is a statement sent in the form of an email by the general counsel of the borrowing entity, Itria, at the time or shortly before the loan was closed. And that regarded a question seeking clarification about a UCC-3 that had been filed. And the statement is objectively true. What was said in the email is not false. What respondent has done in this instance is subjectively construed that statement as being deliberately misleading because it didn't necessarily disclose other things that it might have wanted to know. But the statement itself was true. So you have one affirmative misrepresentation alleged, which is objectively true. And you have a number of alleged fraudulent omissions, which are only actionable if there is an independent duty, of which there is none. Now, with some of the time I still have remaining, I'm happy to stay on this point, but to some extent it's academic as well, because Provident is a quintessential sophisticated party. It's been around for 180 years. It's a highly sophisticated lender. It was conducting a diligence, and the court, the trial court, Justice Barak, very nearly dismissed the cause of action.
But counsel, but under our cases, isn't that, with respect to the due diligence, isn't that really an issue of fact? I mean, shouldn't there be discovery and then on a motion for summary judgment, that determination can be made as to what as to the reliance aspect of it?
Well, of course, ordinarily reasonable reliance is a question of fact. However, it is also routinely decided as a matter of law in instances where a sophisticated entity is complaining about having been duped in a situation where he, she, or it could have otherwise taken action to protect itself. And that's exactly the situation here. And we only need look to what the respondent is saying over in New Jersey to know that that is true. Justice Barak nearly threw this cause of action out in his opinion and at the oral argument on the grounds not that he hadn't concluded that for whatever reason he thought there were actionable misrepresentations, but precisely because of the sophistication of the party, it had a means available to it to readily ascertain what it now says it was duped into not knowing, namely that the appellant and the borrower were still engaging in factoring at the time the loan was being procured, and that there was this account called the 1975 account through which this factoring was taking place. In its lawsuit in New Jersey against its diligence agent, respondent, not appellant, not anyone else, respondent says in a simple and straightforward manner, all it had to do was send a cash notification letter to TD Bank and we would have realized that this account existed. Now, it didn't do that. And the question isn't one of reliance. The question is, could it have protected itself through the ordinary course of exercising diligence? And on this record, that's indisputably yes. Indisputably. Once you get there, then you're in the situation where a sophisticated entity cannot have reasonably relied as a matter of law. All Provident had to do was send this cash notification letter to TD Bank, a bank already identified as having a banking relationship with the borrower, and it would have discovered the 1975 account. That's set forth in the record at pages 536 and 537, paragraphs 72 through 77, in its New Jersey pleading against the entity that it was relying upon that failed to do this. Now, it could have a negligence cause of action against that entity. It very well may. What it doesn't have here is a fraud cause of action for those two reasons. Now, with respect to Mr. Aurora, the individual who is named in the fraud cause of action, he's the president of both ITRIA and Biz2 Credit. In our briefing, we point out that the only two actionable misrepresentation that he's alleged to have made don't go to the efficacy of the theory of fraud that's being advanced. In the first instance, Mr. Aurora is alleged to have said prior to the loan, hey, Provident, you better get along with it because there are others who are trying to close this loan as well, and you're going to lose the business if you don't move things along. And then well after the loan was closed, and well after Provident had already discovered the existence of the 1975 account and the factoring relationship between ITRIA and the borrower Lotus, Mr. Aurora is alleged to have said, oh, I'll intervene with Lotus and make sure that they're not using the 1975 account when Provident's own efforts to police that account had failed.
But Aurora was a corporate, he was a corporate officer, was he not? And so there was that issue of the question as to exactly what his complicity in all of this was. So I mean, it's kind of unclear, is it not, as to him, as to exactly what his complicity is, and also the extent of his personal participation in this?
Well, I don't know that the extent of his personal participation is unclear, because the extent of his personal participation is only bound by what is or is not alleged with respect to what he actually did to carry out the allegedly fraudulent scheme. In this instance, the only thing he's alleged to have done in carrying out the scheme is to have made those two representations that I'm speaking about. One is inactionable. The pre-loan one is inactionable because whether or not others were trying to close the loan, leaving aside whether it's even false, doesn't go to the creditworthiness of the borrower, which is the fundamental fulcrum upon which the fraud theory rests. The post-closing statement about, yes, I'll help you police your borrower with respect to 1975 account certainly didn't lead them to enter into the loan, and it didn't do anything to cause them not to protect a right that they already knew they had, because they had already been trying to police their borrower by insisting that it used a lockbox instead of this 1975 account. So with respect to his actual conduct, in order to be an individual defendant in the cause of action, he has to have himself done things. And the only things he's alleged to have done are not actionable. That issue is not even joined in their briefing. So it suggests to me that they're conceding the point, but in any event, I wanted to raise it. Very briefly.
I'm sorry, you have to continue on rebuttal. Mr. Lupertazzi?
Yes, Your Honors, thank you. Mr. Stokler was prepared to introduce me, but I think he did that during the opening. So I thank the court for its courtesies in allowing me to participate. I would remind the court that this is an appeal of an adverse decision against Itria on motion to dismiss. The court is very aware of the standards of a motion to dismiss, that the pleadings are afforded a liberal construction, that the facts as alleged are presumed to be true.
Counselor, your adversary is making a legal point, and his legal point is that Biz2 Credit had no duty under these circumstances. Could you address that position?
Yes, Your Honor, I can. Thank you. So essentially, part of what Itria is doing here and Biz2 Credit's doing is a little bit of misdirection, in the sense of, let's only look at Biz2 Credit as a broker. Let's only look at this aspect without looking at the rest of the case. So in this case, Biz2 Credit was much more than a broker. Mr. Aurora, a party in this case, was an employee of both organizations, and Corey Fulkin, who is not a party to this case, was an employee of both Biz2 Credit and as to Itria. And speaking primarily of the accounts receivable, it is clear from what we've called the FRSAs, which is the future receivable sale agreements that were entered into between Itria and Lotus Exum before the Provident loan, that there was millions of dollars of funding, and under those agreements, Itria purchased 100% of the accounts receivable of Lotus. And so when Provident, as part of its due diligence, requested information, Corey Fulkin provided account receivable information of Lotus. I'm not concerned whether that account receivable information said 14 million or 12 million or whatever it was. But under the FRSAs that were entered into with Itria involving Mr. Fulkin, Lotus owned no receivables, zero. And so the mere fact of forwarding account receivable information in and of itself was false. Also,
well, but that's not the issue. The issue is there a duty to disclose?
This is not a duty to disclose case. This is an issue of an entity who, by the way, happens to be a
So is it your position there were active misrepresentations being made?
Absolutely, and it's unrelated to them being a broker. And that's why I'm saying we have to look at the entire picture here, which is that Itria, Mr. Aurora, and Biz2 Credit for years had been a lender to Lotus. They had Lotus's financial statements from the accountant in their file. And then they were aware certainly of the TD Bank account ending in 1975. And so when Mr. Falcon forwarded to Provident the bank account information of Lotus, surprise, surprise, the TD Bank account 1975 was not listed on that information. And so on a motion to dismiss, where we have affirmatively alleged that there was active misrepresentations, those are presumed to be true. And my adversary a moment ago said, well, there's only one or two allegations about Mr. Aurora. I would ask the court, when considering this motion, this case, to go to appendix page 241, which is our amended counterclaim, and in paragraphs 36 through 39, at least, in those 4 paragraphs, we alleged that there was active, knowingly false information provided by Biz2 Credit, Mr. Aurora, and in some cases Initria. So we do have a situation where there are numerous allegations. This is a 30-page counterclaim, and we have a little bit
going back to the 1975 account that you just raised, your adversary makes the point that you folks could have done your due diligence and determined, in fact, the existence of that account with not too much effort.
Another misdirection, but with skillful advocacies by Mr. Rossi, Your Honor. So what he's referring to is the accountants for the accountants for Lotus, the entity known as PKF O'Connor, the accounting firm. They performed audit and issued an audit report, 2015 audited financial statements. And under New Jersey law, the accountant can issue a reliance letter to a lender, and that the existence of that reliance letter allows the bank, in this case Provident, to bring a negligence claim against PKF O'Connor. And so what happened was, when we received discovery from PKF O'Connor through the Lotus Exim bankruptcy proceeding under Bankruptcy Rule 2004, we obtained PKF's entire files, and it was shown that PKF, who is not Provident's agent, not Provident's representative, not Provident's contractor, did not intentionally made a decision not to seek cash confirmations from TD Bank. So now we fast forward to Provident's due diligence. We requested the information from Lotus. We requested the information from Biz2 Credit, and Corey Falcon, the employee of both Biz2 Credit and Itria, provided bank account information, which did not include the TD Bank 1975 account. And in essence, what Biz2 Credit is arguing here, or the appellants are arguing, is that a potential lending bank should send a request to every bank in the surrounding area to see if that prospective lender has a bank account. That's not the situation here. We have numerous instances where selected information, false information, was provided to Provident by Itria, Biz2 Credit, and Mr. Aurora. And essentially what's being argued here, I said that one of my themes is a misdirection argument. The other argument that's being made is this is in essence a summary judgment motion where there's been no depositions, where there are disputes as to document production, which is incomplete at the moment. And in essence, the attorneys, if I argued facts, Your Honor should disregard me. And the same thing should be for the appellant. What's being argued by the appellant here is Mr. Gitlin's email is true, is objectively true. The trial court viewed it differently when you look at that language. And I would ask the court to go back and look at the email that Mr. Gitlin sent, as well as the background information. And so on a motion to dismiss, that results in, when we have these disputed facts, such as the Gitlin email, such as the fraud by commission, not just omission, but fraud by commission, then that results in the motion being denied. I just want to make a couple comments about the sophisticated party and also about the role of PKF O'Connor and the role of cost reduction solutions, where the appellants argued that we pursued due diligence. So beginning in May of 2016, this loan was not funded until January of 2017. Beginning in May of 2016, Provident was seeking information which was being provided by Lotus and Biz2 Credit. Biz2 Credit negotiated the term sheet. We have the emails from Corey Falcon, provided all types of information on inventory, accounts receivable, doing business names, bank accounts, it goes on and on. And then, but as part of that, Provident Bank did not hire PKF O'Connor, but did ask for the audited financial statements, which were provided from Itria's files, not from Lotus, from Itria's files. And any lender, by the way, that's pretty standard. You get financial information, financial reporting from your borrower. And Itria had that lending relationship with Lotus from 2014 through 2017. And when those financial statements are given to a lender, they look at them. And in that financial statement, there's no reference to the Itria funding. And indeed, post-closing of the Provident loan, we've included in the record the emails between Lotus, it originated with Lotus, going to Itria saying, as you know, your financing is not disclosed in those financial statements. And so we have that type of issue. And the accountants who are not our agent did a negligent audit for which they have liability. That does not provide an excuse. That does not provide a defense to Itria. The other entity, Cost Reduction Solutions, was hired by Provident solely to verify account receivables. And what Cost Reduction Solutions did, as well as what the accountants did, we found out afterwards, was Itria, instead of Cost Reduction Solutions calling account receivable customers of Lotus, they allowed Lotus to send emails to the customers and have the customers reply to those emails. So there was no issue of determining ownership of accounts receivable. It was just whether or not accounts receivable were valid. Unfortunately, those account receivable emails were fictitious, and the same procedure, unbeknownst to us, had been followed by the accountants. So we have a negligence claim both against PKF O'Connor and against Cost Reduction Solutions, which are completely unrelated to the wrongful actions of Itria. And as Justice Borak recognized, that there also may be liability of those two entities, does not give a pass, so to speak, to Itria, Biz2 Credit, and Mr. Aurora. It's not disputed that Lotus was engaging in very wrongful behavior, and there have been federal guilty pleas by Mr. Quinqueria.
Thank you, counsel. Any questions? Any questions? Thank you. Mr. Rossi, you have, I think, 2 minutes on rebuttal.
Oh, thank you. So briefly on rebuttal. The court is absolutely correct to hone in on this question of duty with respect to the alleged fraud of omission. We can only judge fraud by how it is alleged, and this state and this court in particular is meticulous about making sure that fraud is properly alleged. In this instance, there is either fraud of omission or commission. I would direct the court to page 239 of the record, paragraph 30 of the amended counterclaim. In it, Provident states, neither Corey Falcon nor Aurora, two employees of Appellant, nor any representative or agent of Biz2 Credit ever disclosed to Provident that Itria had been factoring Lotus XM's accounts receivable since at least 2014, and that Itria owned 100% of Lotus XM's accounts receivable pursuant to the terms of the pre-closing FRSAs. Ever disclosed. It is a fraud of omission case that is searching still, despite 3 direct questions to respondents' counsel, for a duty. And absent a duty, even if you have motive, even if you have knowledge, what you don't have is the obligation to disclose. And so unless and until there's a duty, there's no fraud. Even assuming that somehow there was a affirmative misrepresentation or a properly pled omission with a cognizable duty.
Well, your adversary called it an active misrepresentations.
I believe in the briefing they call it active concealment and misrepresentations. I'm not a grammar teacher, but fundamentally there is no difference between concealment and active concealment. Using the word active in front of concealment changes nothing. It is just a way to dress up their pleading, and it seems to have caught the trial court's eye. Notwithstanding that, the trial court otherwise would have applied the well-settled principle of this court in HSH Nordbank to throw this cause of action out, but for the fact that it found a narrow exception. The narrow exception it found was that under the ACCA case that the Court of Appeals came out with in 2015, if something is peculiarly within the realm of the entity that you're seeking the knowledge from and they don't disclose it, then that can be an exception to the otherwise ironclad provision that you have to protect yourself if you're a sophisticated entity. In this instance, the court did not properly apply, nor have they properly alleged that exception. As we set forth on page 16 of our reply, that exception requires three things. The plaintiff itself has to seek assurances. It has to expressly seek assurances. It did not do so in this case. There's no allegation that it did. It has to seek assurances about information that's peculiarly within the realm of the person who's the assurance is being sought from. It did not do that. And then the defendant has to actually affirmatively misrepresent. In the ACCA case, Goldman was asked by the plaintiff, Goldman Sachs, is your counterparty to this CDO in an equity position or in a short position? That was an assurance they sought. They could have moved heaven and earth in diligence and never been able to know that. Only Goldman knew that. And Goldman lied in response. That is when the exception applies. Not in an instance here where, by their own admission, as I've set forth, in my opening statements, in the record, in New Jersey, in their cause of action, they say you can very simply discover whether or not an account exists simply by asking a bank to let us know what account exists. And in this instance, they would have, but for the fact that the audited financials that they were relying on, the auditor had failed to do so.
Thank you, counsel. Thank you both. Thank you both.
Thank you, Your Honors. Thank you.
Take care. The next case is Shapiro versus the City of New York.
Good afternoon, Your Honors. My name is Judy Shamet-Sam with Wilson Elster. I respectfully request that the underlying administrative determination be reversed to give meaning to all of the terms in the statute is to understand that the preparer of the plan had to make a determination about what ground surface elements were pertinent and was required only to include those in the plan which were, regardless of the other requirements of the statute. Here, the determination is unrebutted. Mr. Shapiro testified in his own behalf as his own expert that the manhole at issue was completely irrelevant to the placement of the crane, and therefore it was appropriate for him to not include it.
I don't understand that. I don't know much about these things other than, having read the briefs, etc. Why would it not be relevant to show where the manhole was? I mean,
because nothing is touching it.
What do you mean nothing is touching it?
The manhole is recessed, so it lays underneath in a little bit underneath the surface. The crane is going on a plate, basically a tray, a very large tray.
Yeah.
So the manhole is here. The tray goes here, so not touching the manhole.
But this huge crane that is, you're saying not touching the manhole, is the manhole still accessible?
The manhole is completely covered by the plate, completely covered on all sides.
And isn't that relevant?
No, because the plate is not going to impact the manhole in any way. The plan is for how to safely erect this.
Counselor, is that what the rule is trying to do? Because my understanding of the rule is it just wants to detail the ground and subsurface elements, and then the rule goes on to say, including as applicable, and then there's a list of other items, including manhole covers. Isn't the rule just asking, what are the subsurface elements that the crane or the cover will be sitting on?
The rule is asking for anything that is relevant to the crane. There can be any number of things going on the ground that are not relevant to the crane.
Well, that's one aspect.
Case,
that's one aspect. That's the pertinent aspect, correct? That's the rule says pertinent. But then the rule goes on to say, including as applicable. So wouldn't you, just as a matter of statutory interpretation, apply both sets of the rule? And if there's a manhole under the cover, it seems to me, wouldn't it fall under including as applicable?
It would have to hit all of the requirements of the statute in order for it to be, because
so it has to be pertinent, has to be pertinent and including and applicable.
Correct. It has to be, because it asks you to detail all of the things that are pertinent, included on the list, and applicable. That is the plain language, and it's extremely compact, but that is the only way to give meaning to all of those words. Otherwise, you can leave pertinent out, and you have the same result.
Counsel, if this is just an issue of statutory interpretation, and you're saying just look at the plain language, then why would an expert's opinion regarding whether the crane is hazardous or any engineering analysis, why is that even pertinent if we're just looking at interpreting the statute?
It is for determining this particular application, there are two things that have to be decided. What is required to be included in the plans, and B, were those things included? On B, on the second part of it, there is no challenge from the city that the manhole here did not impact the crane. So that part is undisputed. So if it is true, as it is undisputed, that the manhole is not relevant to erecting this crane, then it triggers that pertinent filter, and it sort of gets held up on that, and that's why it doesn't have to go into the plan, because it doesn't matter for the crane that the manhole is there, because it is below where the crane is going.
So you're apparently defining pertinent to include if it's dangerous, right? If there's some kind of danger, right? Is that
effectively so? It has to be relevant in some way, and usually when you're putting up a crane, the relevant thing is it going to be a problem?
And where are you drawing that from? I think you're freezing. I don't think I'm freezing.
I apologize. Well, it's probably me, but in any event, if you're on, mind repeating the question.
I was saying, where are you drawing that from? This definition of pertinent as being somehow dangerous.
It doesn't have to be. I think functionally, it's going to end up being the thing that is dangerous. But pertinent in its ordinary meaning is going to mean relevant too. I'm not trying to define pertinent as dangerous. I'm just saying that as a matter of practicality, that's what it's going to shake out to be. But however we decide, however we think of pertinent as it relates to its ordinary meaning, this particular manhole is in no way pertinent, is in no way relevant to the placement of the crane.
Thank you, Councilor. You have 2 minutes on rebuttal.
Thank you, Your Honors.
Good morning, good afternoon, Your Honors, and may it please the court. I'm Alan Racinas for the city respondents. So the text of the rule here, Your Honors, is very simple. It says basically the engineer should detail all pertinent ground and subsurface elements, including as applicable manholes. So the three words or phrases that are relevant here are pertinent, including, and as applicable. And our reading gives each of those words or phrases a simple, straightforward meaning. Pertinent means, to quote Shapiro's own brief on page 10, his appellant's brief, pertinent to the placement and operation of the crane. We agree with that definition. Including means that the list that follows contains some but not all pertinent elements. And as applicable, as both the ALJ and the Oath Appeals Board found, means that only those elements that are actually present at the crane site in question need to be included in the plan. As we said as we suggested in our brief, when you have a sentence that says all pertinent things, including X, Y, and Z, that necessarily implies that X, Y, and Z are pertinent things. Now, they say, oh, well, Shapiro says, well, we said any in our brief, any pertinent things, not all. It doesn't matter whether you use the word any or the word all in that sentence. It has the same effect on the list that follows. Shapiro is trying to say that our reading of the word pertinent is unnecessary. But as we said, that's simply not true. If you were to take out the word pertinent and it just say all ground and subsurface elements, that would mean that every element would need to be included, no matter how inapplicable to crane site plans it would be. And as your honors point out, here you can see on page 27 of the brief, this manhole sits directly beneath the crane, one of the crane's 4 cribbing plates. I think there are 4 in the event, one of the few cribbing plates. We never said, they say in their reply, Shapiro says his reply, we suggested that it was touching it. We never suggested that. In fact, the same page of our brief where we say beneath, we put out that Shapiro says it's not touching it. But the point is, it's right beneath it. And but the bigger point, your honors, is that by the text of the rule, everything on the list, including manholes, is categorically pertinent. There may be other things on a crane site that are pertinent only in some cases, because maybe they're rare, or they're not listed for some other reason, like maybe there are divots in the asphalt or something that might be pertinent, but that's fairly rare. But everything listed is categorically pertinent by the text of the rule. So again, this idea that pertinent under our reading is somehow superfluous is not true, because it doesn't. Not every element needs to be on the plan, only pertinent elements, but it defines the items in the list as categorically pertinent.
Well, they're defining pertinent, that it's not pertinent because it's not touching the manhole, that it's over the manhole. Is there any interpretation of the statute which would lend credence to their interpretation? I mean, is there anything in the statute which would lend credence to their interpretation? That pertinent would be touching?
I don't think so, Justice Weber. I mean, when you look at the other items on the list, there are, for instance, vaults on the list, which are compartments beneath a public street. So a crane would never touch those. Subways, stations, and entrances. It's hard to imagine a crane touching those. Utilities impacted by the tower crane foundation. The water table level. The crane would never touch any of these things. So it's fanciful to say that unless it's touching, it's not relevant. And this idea that they're also kind of saying that, Shapiro is also saying that it's only pertinent if it's dangerous, at least when it comes to manholes. Well, in his testimony, he says that manholes are always able to withstand, in New York City, manholes are always able to withstand the maximum weight that cranes can exert. So under that definition, under his understanding, according to his testimony, you would never have to put a manhole on a crane site plan. It basically reads it reads the word manholes out of the rule, which is the third problem with his interpretation. In his reply brief, he says, well, no, because if all the asphalt around the manhole were stripped away, so the manhole was sticking way out in the street, then it would still be pertinent. Well, that's again pretty fanciful to say that's the only instance where one of these only 12 or I guess 13 and 14, there's 11.1, 11.2, so 13. One of these things applies only in this very strange and bizarre instance. That seems unlikely. So he also says in his reply brief, well, maybe it just means to apply to the future. Maybe it doesn't apply now at all, but manholes may in the future change, their specifications may change so that they could be dangerous in the future. Again, that's fanciful, Your Honors. These rules were relatively recently amended. you don't draft rules to apply only in the future and not in the present. And manholes have been a staple of city life for I don't even know how long, certainly decades, maybe a century. This idea that you would only put in manholes to apply in some indefinite future time is simply shows how tortured Shapiro's reading of the statute is.
Thank you, Counselor.
Thank you, Your Honor.
Ms. Amachi, you have 2 minutes.
Again, thank you, Your Honor. The meaning of the word pertinent is its ordinary meaning. We are not asking this court to reinterpret that phrase. So pertinent can mean, depending on what we're talking about, different things, but certainly it is some variant of relevant. And yes, a manhole may be relevant, but it may not be, depending on where the crane is, where the manhole is, what kind of manhole it is, and everything else.
I'm sorry,
on the
Counselor,
list.
the rule doesn't seem to support that interpretation. I mean, you're making it. The rule just simply says that the engineer shall detail all ground and subsurface elements that are pertinent, and then goes on to say, including, as applicable, manholes, and which is then as a subcategory of other items.
Sure.
It's not what you're saying the rule is, correct?
Well, no, I think I'm right. But
Okay.
the reason I think I'm right is because the term including already signals that this is not an exhaustive list, right? So the idea that you need the term pertinent to signal that this list is not exhaustive renders one of those two redundant.
Okay.
Thank you, Counselor.
Thank you, Your Honors.
Thank you very much. Next case is People v. Carlos DG.
May it please the court, Your Honor. My name is Paul Wiener, appearing for Appellant Carlos DG. Appellant was deprived of his Sixth Amendment right to a jury trial. The issue here is whether the top charge that he faced, a misdemeanor of forcible touching, was a serious crime requiring a jury trial under the Sixth Amendment, or whether it was merely a petty offense.
Is that the issue?
Counsel.
He was YO eligible. So given the fact that he was YO eligible, even though that charge carried a maximum 1-year term of incarceration, because he was a mandatory YO, he could only have been sentenced to a maximum of 6 months incarceration, and therefore he would not be entitled to a jury trial.
Well, Your Honor, under People v. Suazo, the Court of Appeals recently made it clear that while the maximum exposure, jail time exposure, is a very important fact, it's not the only consideration. And in fact, in Suazo, you had a defendant who the top charge was actually a B misdemeanor. And in that case, the court found that there were other considerations. What's critical is in Suazo.
Well, counsel, People v. Suazo is not persuasive here because, yeah, there were A misdemeanor charges reduced to B, but there was also the possibility of deportation, which is totally different here.
So, Your Honor, what's critical is in People v. Suazo, the Court of Appeals emphasizes that the main consideration is whether or not I'm sorry, I'm just going to read. It's the language is whether it's considered serious enough by society. So you look at the Court of Appeals said you look at how society views the crime. And the problem here is if my client had been convicted of the A misdemeanor here, he would have faced enormous social disapproval for the rest of his life. He would have been convicted of, again, an A misdemeanor, which is the most serious misdemeanor. He also would have been convicted of a sex crime called forcible touching. And even though there was no force here, a lay person would not have understood that. So he would have been carrying around that social disapproval and would have had to explain this for the rest of his life.
Could that conviction have been sustained on appeal based on the fact, as my colleague pointed out, he's entitled to mandatory YO? I mean, I don't understand how that would even come about.
I'm sorry, Your Honor, could you repeat the question?
I mean, how in the world could your client be convicted of a Class A misdemeanor where he's entitled to mandatory YO?
Well, there was a jury trial, and the top charge was an
There was no jury trial.
I'm sorry. I apologize, Your Honor. There was a bench trial. My mistake. He went to trial, and the top charge was an A misdemeanor. And
well, okay, let's assume the judge forgets the law and convicts him of the A misdemeanor. On appeal, the result would have been reversal, correct? Because he would be entitled to mandatory YO under CPL 340.47. No.
Yeah, but
so what am I missing?
So, counsel, your argument is that based upon People v. Suazo, that the court was looking at how society would view him because he was convicted of this serious crime. And so you're saying that if he were convicted of the forcible touching, that's a serious crime, and therefore society is going to look upon him in a certain way. Is that your argument?
Exactly.
However, he's mandatory YO. So that conviction it's not a conviction, it's an adjudication of YO. And so therefore it is sealed. And so therefore society, other than in some instances where that case could be, where the YO could be unsealed, society would not know, and society would not therefore look upon him in any particular way, because society, i.e. the community, would not know of that conviction because, again, he's a mandatory YO, and the adjudication, because it's not a conviction, would be sealed. So I do not understand your argument. My colleague, Justice Kennedy, what she was referring to in terms of Suazo also was that the Court of Appeals was concerned with collateral consequences. The collateral consequences of a conviction by a non-jury trial, and the possible collateral consequences, and in that case, deportation.
Your Honor, first of all, he went to trial. It was a public trial. There were presumably people at the trial. It wasn't closed to the public. So the public was able to view the trial. He went through it. He was convicted. It's true that he is going to get YO, and he will have certainly a level of protection as a result. But nevertheless, people may ask him, why did you do that year of probation and the 10 days of community service for the rest of his life? What were you convicted
Counsel, I don't know. That's your strongest argument, because you're talking about it's a public trial. Obviously, if it's a jury trial, there are more members of the public, i.e. the community, who are going to be present, because they're individuals from the community who would therefore know exactly what occurred. So there'll be 12 individuals from the community who would be aware of what the charges were, as opposed to one judge. But you can reply on rebuttal. People?
Good afternoon. Rachel Bond for the People. The defendant here was not deprived of his right to a jury trial because he was not entitled to a jury trial based on his status as a mandatory youthful offender under CPL 340.40 subsection 7. And in fact, defendant concedes that as well, that he was a mandatory youthful offender. And therefore, he was only facing a maximum of 6 months in jail. And not only that, but under CPL 340.40 subsection 7, mandatory youthful offenders only get non-jury trials, bench trials. And additionally, although defendant cites Suazo and makes the argument that the controlling factor is how serious society sees these crimes, he stops short of the full context of that quote. The extended quotation is that whether the charged crimes are considered serious enough by society based on the penalties associated therewith. So ultimately the critical factor in any case is going to be what the ultimate penalties can be. And
but
here
it also deal with A misdemeanors, did it not?
I believe Suazo was B misdemeanors.
So, which was even less than what this defendant would have been facing.
Yes. Yes, Your Honor. And in addition, Suazo, as I believe it was Justice Kennedy and yourself, Justice Weber, had suggested or had stated that Suazo focused on other collateral consequences of a trial, even if it's only for B misdemeanors, such as deportation. And here, because the defendant was a mandatory youthful offender, he actually received more leniency and receives more leniency and fewer collateral consequences as a result of that adjudication. So he's facing fewer collateral consequences, whereas in Suazo, the court was looking at more collateral consequences as the result of a conviction or adjudication. And if there are no further questions, I would just rest on our brief and we would ask that the judgment of conviction be affirmed.
Thank you.
Your Honor, just briefly, I'll point you to the language in Suazo. It's at 496 and 497. There's a lot of language about how you view this, how society views this. Certainly, this was a penalty. If he had been convicted, this would have been, of an A misdemeanor, and not just any A misdemeanor, an A misdemeanor, a sex crime, a forcible touching that he's going to have to explain for the rest of his life. If somebody says to him, why did you do that year of probation? What was it for? What was it for? Why did you, he's going to have to answer these questions. It's going to be essentially a scarlet letter around it. Had he been convicted of that A misdemeanor, again, a sex crime, forcible touching, and I think society would have viewed that, very seriously. And
he was not convicted of that crime.
Right, but the point is that he was entitled to a jury trial because that was the top charge that he faced. If he had been,
I could possibly maybe understand your argument if, in fact, he had been convicted of the forcible touching. But even then, as I stated, because it's a YO adjudication, it's sealed. The record is sealed. Society does not and would not know about it. When he applies, we're talking about collateral consequences. When he applies for a job, they're not going to know about it. So that is what I do not understand. And as I said, since he was not convicted of the forcible touching, again, I'm not understanding your argument.
Well, Your Honor, it's not. The question is whether the judge made a mistake. It doesn't matter whether he was ultimately convicted of forcible touching or not. It's what he went to trial for and whether he was entitled to a jury trial at the time. And he wasn't given the jury trial, even though he had an A misdemeanor. And with all due respect, again, he had a year of probation, 10 days of community service. If people ask him about that, he's going to have to explain it. And this was a public trial. So I understand that getting the YO seals it to a large degree, and there's some protection, but still, there's an enormous danger that a lot of people throughout his life at various points might ask him about this, and we'll view this in a disapproving way.
Any different if he had been convicted by a jury as opposed to having been convicted? Are the answers any different if, in fact, the judge had convicted him of the forcible touching and he had gone to trial and the jury had convicted him of forcible touching? Are his answers to society any different?
I mean, if he had been convicted of the forcible touching
by a jury.
If he had been convicted of the forcible touching by a jury, then we wouldn't be here because, he would have had a jury trial. But he wasn't. He was entitled to a jury trial. And he didn't get that, and that was a violation of his, Sixth Amendment right.
Thank you very much, Counselor. Very interesting argument. Thank you.
Thank you, Your Honor.
Thank you both. Last but not least, Markelson versus Samadi.
Good afternoon, Your Honors. May it please the court. My name is Nicholas Tam, appearing for Shabami, Citron, and Spratt on behalf of Lenox Hill Hospital, as well as Northwell Health.
So I have a question. We received a stipulation of withdrawal as to some of the defendant, the Samadi, as to one action. Is that correct? So now what is the status of as to two actions, Mr. Lanny? So what is the status now?
Right. So this is a triplicate appeal. Justice Madden's order covered 3 cases: Markelson, Pino, and Marcados. So the only action that's active right now is Marcados on behalf of both the hospital as well as the surgeon. So Marcados is the only active.
So this is the September 30th order. Is that's the subject of this appeal, counsel?
Yes, it's the order that covers all 3 of them. Yes.
Okay.
So just jumping right into it, there's 2 issues. First is the dismissal of the General Business Law 349 claim, and the second one is the propriety of the punitive damages. I just wanted to inform the court of a recent decision by this court 2 weeks ago, one upon which Justice Weber was sitting on the bench at the time and was involved with the decision. It's another triplicate appeal regarding similar.
Nadler versus Samadi.
That's correct. And the active case in that one was Ross. This court, in that decision that was issued 2 weeks ago, held that the GBL 349 claim should have been dismissed because the statements were not consumer conduct. As to the punitive damages claim, this court permitted punitive damages claim to go forward at this stage. And that's the one I briefly wanted to touch upon today. I don't want to relitigate the entire.
Counsel, you're asking Justice Weber to overrule herself? Is that your position here? And that the rest of the judges should not follow?
Sounds like it.
Judge, I just wanted to make.
Let me finish. And that the rest of this bench should not follow the precedent set by our colleagues?
Well, Justice, I believe that courts can change their mind depending on their interpretation of the facts in the law. And the only case that I wanted to bring up today was Spinoza versus Weinstein, because I believe the underlying, or rather the decision in Ross, did not touch upon this, and I think it's critical in the understanding of what happened in this case. Punitive damages is the strongest sanction in civil law. It's inappropriate here because there is no morally culpable conduct on behalf of the hospital. It was not.
In Nadler, we say that the defendants colluded in a scheme whereby they would systematically and knowingly misrepresent to urology patients that Dr. Samadi was doing the operation. It sounds like sort of like they're committing fraud, right? And that's what the claim is. Well, wouldn't that be a basis at this juncture to allow it to go forward?
Well, Justice Singh, as to the issue of fraud, that cause of action was dismissed by Justice.
No. I'm talking about the punitive damages.
Okay. Yes.
But so there's a scheme that Dr. Samadi was engaged in. That's what the punitive damages go to. Why isn't that proper at this stage?
Judge, Your Honor, I just want to make a distinction. The alleged representations were made by the surgeon, Dr. Samadi, which is the co-appellant in this case, Ms. Fasano. We represent Lenox Hill Hospital. So where there's a corporate institution involved in a purported fraud scheme, as you pointed, there's a level, there's an additional inquiry, which is whether the corporate institution was complicit.
I'm sorry to interrupt, but we then go on to say that there's questions here as to whether or not Lenox Hill was complicit in this conduct based on falsifying allegedly operative reports or bills. Isn't that
just the same?
Lenox Hill?
Respectfully, no, because in this case, we have to apply the Spinoza doctrine, which states that economic gain conduct actuated by economic gain by itself is not sufficient. So where there's allegations of falsified billing on behalf of the hospital, that in and of itself under the Spinoza doctrine is insufficient.
But the assertion is that it ratified his conduct through these actions. That's what we say. So it's they're not seeking punitive damages because there was falsified billing. The issue is that's the link between Lenox Hill and Samadhi.
Yes, so the ratification that's alleged in the complaint is completely conclusory and speculative. There is no specific link where the plaintiff can point to an action or an omission by someone at the hospital that actually ratified the conduct of Dr. Samadhi, that actually went along with the representations made by Dr. Samadhi during his one-on-one discussions with his patient regarding treatment. Your Honors, if there are no more questions, we rest on our briefs. Thank you very much.
Is this second appellant? Yes. You're muted, Ms. Rasmussen. There you go.
Are we good? Okay.
Yeah, you're good.
Good afternoon, Your Honors. Jacqueline Pisano for appellant Dr. Samadhi. I just want to I have nothing to add, and we rest on our brief. Thank you.
Thank you. Mr. Lanning?
Yes, good afternoon, Your Honors. May it please the court. The claims in this case are identical to the claims in the Nadler versus Samadhi case that was recently decided by this court. Case number for this is 2019-4414. The decision was published on November 17th, 2020. And as Mr. Tam said, the Ross case affirmed the decision of the court below with regard to the punitive damages claims. These are pleading motions. Clearly, the Nadler case is precedent for that guides this court accordingly. If the bench has any questions, I'm glad to entertain them. Otherwise, we rest on our brief. And on the decision in the Nadler versus Samadhi case that was just published 2 weeks ago.
Thank you. Any questions? Thank you all very much. Thank you.
Thank you. Take care.
That concludes the calendar for today, December 2nd, 2020. Court is in recess. Thank you.